One would surmise that drafting a testament is paramount for any affluent individual, particularly for a thriving luminary whose personal holdings might escalate to tens or even hundreds of millions, if not surpassing this mark. Nonetheless, a multitude of celebrities seem to lack the resolve to establish this quintessential document, resulting in a myriad of legal conundrums for those left in the aftermath. Peruse further to uncover which notable figures departed intestate, as where there's a will, there's indeed a way. Abraham Lincoln, 1809 to 1865. Abraham Lincoln, the 16th President of the United States, fell victim to an assassination by John Wilkes Booth on April 14, 1865, succumbing to his injuries the subsequent day. Despite his repute as a distinguished attorney, Lincoln overlooked the crucial task of drafting a will. This lapse incited a protracted legal skirmish spanning 2 years, as Lincoln's kin endeavored to secure authority over the late president's holdings. Pablo Picasso, 1881 to 1973. Upon the demise of Spanish painter and sculptor Pablo Picasso at the venerable age of 91 on April 8, 1973, he bequeathed an extraordinary legacy comprising roughly 45,000 pieces of art. Yet, curiously, he neglected to formalize a will. The renowned Cubist maestro also possessed multiple residences and had amassed a substantial trove of gold and liquid assets. The resolution of his estate ensued in a protracted, 6-year saga marked by frequent, acrimonious negotiations among relatives and other claimants. Howard Hughes, 1905 to 1976. Eccentric billionaire and notorious recluse Howard Hughes passed away on April 5, 1976, at the age of 70, standing as one of the world's wealthiest individuals. Despite his immense fortune, Hughes left no direct descendants or immediate family, and crucially, he did not leave behind a will. This omission ignited a chaotic scramble for control over his vast estate. A purported will, allegedly penned by Hughes, was later dismissed as a forgery. Among those named as beneficiaries was a gas station proprietor, Melvin Dummer, who claimed that in 1967 he had given a lift to a bedraggled man lying by the roadside in Nevada. This man purportedly introduced himself as Howard Hughes. Years later, Dummer asserted that he had received a copy of the will, entitling him to approximately $156 million. This intriguing tale inspired the 1980 film Melvin and Howard, directed by Jonathan Demme. Ultimately, Hughes' immense fortune was divided among relatives from both his mother's and father's lineage. Jimi Hendrix, 1942 to 1970. The abrupt and untimely demise of Jimi Hendrix, ascribed to asphyxiation exacerbated by substance misuse, led to the legendary guitarist exiting this world without a will. Regarded by many as the preeminent virtuoso in rock music history, Hendrix's passing incited a protracted and tumultuous legal struggle over his estate, enduring for over 3 decades. James Dean, 1931 to 1955. James Dean achieved legendary status after a tragic accident involving his Porsche on a California highway on September 30, 1955. His death was almost instantaneous, and he had not prepared a will. Consequently, state law dictated that the majority of his modest estate be awarded to his father, Wynton. Over time, the inheritance passed into the hands of his father's relatives. Amy Winehouse, 1983 to 2011. During her brief yet profound career, English singer-songwriter Amy Winehouse left an indelible mark on the global music landscape. Tragically, she succumbed to alcohol poisoning on July 23, 2011, at the tender age of 27, without having drafted a will. Consequently, her entire probate estate, which purportedly held an after-tax value of nearly $4.7 million, was inherited by her parents. Prince, 1958 to 2016. Prince, one of the most seminal recording artists of his era, tragically succumbed to an accidental overdose of fentanyl, a potent opioid, on April 21, 2016. His lack of a will precipitated a chaotic aftermath, with an astounding 700 individuals coming forward, each professing to be a sibling in hopes of securing a portion of his substantial fortune. Martin Luther King Jr., 1929 to 1968. Assassinated on April 4, 1968, Martin Luther King Jr. departed this life without leaving a will. This absence of foresight precipitated familial discord, with his children embroiled in disputes over the estate. Allegations of mismanagement and asset misappropriation further fueled the contention. Bob Marley, 1945 to 1981.
Cancer claimed the life of reggae legend Bob Marley on May 11, 1981.
He passed away without a will, adhering to the belief that drafting such a document demonstrated an undue preoccupation with worldly affairs, as noted by the Caribbean National Weekly. It wasn't until 1991 that his estate, valued at approximately $30 million at the time of his death, was legally settled and entrusted to his family.
Kurt Cobain, 1967 to 1994. Kurt Cobain took his own life on April 5, 1994. The iconic Nirvana frontman left behind a widow and a young daughter but did not prepare a will. Under the laws of intestacy, Cobain's wife, Courtney Love, was granted the authority to manage his estate. This led to extensive legal battles and lawsuits. While Love continues to benefit financially from Cobain's legacy, it is his daughter, Frances Bean, who holds the rights to her father's name and image. Tupac Shakur, 1971 to 1996. At the tender age of 25, rapper and actor Tupac Shakur likely never contemplated the necessity of drafting a will before his life was abruptly ended in a Las Vegas drive-by shooting on September 7, 1996. In the absence of a will, his mother, Afeni Shakur, took charge of managing his estate until her passing in 2016. As of 2019, Tupac's estate was estimated to be valued at approximately $40 million, with its management predominantly overseen by the record companies with which he collaborated. Sonny Bono, 1935 to 1998. Salvatore Philip Sonny Bono, renowned as one half of the iconic musical duo Sonny and Cher, later transitioned into a career in politics. In 1994, he was elected to the United States House of Representatives, representing California. Tragically, he perished in a skiing accident in 1998 without having drafted a will. This omission resulted in his estate being subjected to the California probate process. His wife, Mary, was compelled to petition for appointment as executor, thereby complicating the situation and escalating legal expenses. Barry White, 1944 to 2003. Barry White, the maestro who seamlessly blended soul, funk, and disco, crafting an iconic sound emblematic of the 70s, passed away on July 4, 2003. Despite enduring deteriorating health in his later years, he did not revise his will for a significant period. This oversight meant that his family, already stricken with grief over the loss of the man endearingly dubbed the Walrus of Love, faced additional legal complications. Stieg Larsson, 1954 to 2004. Swedish journalist and novelist Stieg Larsson achieved global acclaim posthumously with his Millennium series of crime novels, notably The Girl with the Dragon Tattoo, which was transformed into a blockbuster film starring Daniel Craig. Tragically, Larsson passed away suddenly on November 9, 2004, at the age of 50, before witnessing his international success. Without a will, Larsson's 32-year partnership with his companion and collaborator Eva Gabrielsson was not acknowledged by Swedish intestacy laws, thereby precluding her from inheriting his substantial literary estate. Had the couple been married, she would have been entitled to the rights to his works. Instead, Larsson's entire estate was apportioned between his father and brother. Marvin Gaye, 1939 to 1984. Motown icon Marvin Gaye was tragically shot and killed by his father on April 1, 1984. The celebrated singer passed away intestate and burdened with substantial debt. Gaye's legal representatives were compelled to seek court-appointed administrators to manage the repayment of his creditors. Over time, the estate successfully settled the debts, allowing Gaye's children to equally share the income generated from their father's royalties, image rights, and the rights to his life story. Billie Holiday, 1915 to 1959. Billie Holiday, an iconic singer of the jazz and swing era, departed this life on July 17, 1956. She passed away without a will, resulting in her estate, including all royalties, being inherited by her fourth husband, Louis Mackay, from whom she was estranged but not divorced. John Denver, 1943 to 1997. When the plane John Denver was piloting tragically descended into Monterey Bay on October 12, 1997, the music world mourned the loss of one of its most cherished singer-songwriters. Denver passed away intestate, and his ex-wife Annie, the muse behind his massive 1974 hit Annie's Song, was appointed as the estate's administrator. Ultimately, his assets were divided among his 3 children. Rita Hayworth, 1918 to 1987.
One of classic Hollywood's most illustrious icons, Rita Hayworth, passed away on May 14, 1987, without a valid will.
Consequently, her daughter, Yasmin Aga Khan, was designated as the administrator of her estate by the New York Cygat's Court. Duke Ellington, 1899 to 1974.
The renowned composer, pianist, and jazz orchestra leader Duke Ellington passed away on May 24, 1974, without a will.
As a result, his entire estate was inherited by his son, Mercer K. Ellington.
Jane Mansfield, 1933 to 1967. Hollywood actress and glamorous pinup Jane Mansfield perished in a horrific car accident on June 29, 1967. She died intestate, leading to a contentious battle over her estate. Various parties, including her two ex-husbands, Mickey Hargitay and Matt Clymer, along with her business manager and other estate administrators, filed lawsuits seeking control. However, none were successful in gaining full authority. George Gershwin, 1898 to 1937. Composer George Gershwin, renowned for masterpieces like Rhapsody in Blue, 1924, and An American in Paris, 1928, achieved immense success and amassed a significant fortune during his life. However, he never drafted a will.
Following his death on July 11, 1937, Gershwin's entire estate was inherited by his mother, Rose Gershwin. Sam Cooke, 1931 to 1964. Influential soul artist Sam Cooke met a tragic end when he was shot by the manager of a Los Angeles motel on December 11, 1964. He passed away without having drafted a will, leaving him unable to dictate the distribution of his estate according to his wishes. Nate Dogg, 1969 to 2011. Had rapper Nate Dogg drafted a will before succumbing to heart failure on March 15, 2011, his 6 children would have inherited a considerable cash fortune and property portfolio. At the time of his death, he was divorced, thus leaving no surviving spouse to inherit under intestate succession laws. James Brown, 1933 to 2006. Even when celebrities remember to draft a last will and testament, they can sometimes be deficient due to a lack of clarity or simple oversight. Although James Brown left a will, it lacked specificity, particularly regarding the status of his last partner, Tommy Ray Heine, who claimed to be his wife but had not annulled a previous marriage. As a result, she was not entitled to his multi-million-dollar estate. Instead, a significant portion of the wealth accumulated by the Godfather of Soul was allocated to children's charities, in accordance with his dying wish. Heath Ledger, 1979 to 2008. Hollywood lost one of its most luminous talents when, on January 22, 2008, Heath Ledger succumbed to an accidental overdose of prescribed medications. The acclaimed actor had indeed drafted a will, but had not updated it to include his daughter, Matilda, born in 2005 to his partner Michelle Williams. Fortunately, Ledger's parents and sisters chose to bequeath everything to Matilda, ensuring her future security. Michael Jackson, 1958 to 2009. Michael Jackson's sudden passing on June 25, 2009, sent shockwaves around the globe. It was revealed that the King of Pop had indeed drafted several wills, each of which was subsequently disputed by various members of the Jackson family, some of whom were excluded from any inheritance. Despite these legal battles, the estate continues to generate millions of dollars. Adam Goldstein, 1973 to 2009. DJ Adam Goldstein, known professionally as DJ AM, rose to prominence in the vibrant nightlife of Los Angeles and Las Vegas. Tragically, he succumbed to an accidental narcotics overdose on August 28, 2009. Leaving behind a $1 million estate and no will, his mother became the sole beneficiary. J. Howard Marshall II, 1905 to 1995. One of the more peculiar instances of a contested will in recent history involves billionaire businessman J. Howard Marshall II, who was married to Anna Nicole Smith during the final 14 months of his life. Following Marshall's death at age 90, Smith became entangled in a legal battle with her former stepson, E. Pierce Marshall, over a portion of the magnate's fortune. Ultimately, she did not succeed and passed away in 2007 due to an accidental overdose of prescription drugs. J. Howard Marshall II is depicted at Haverford College in 1925. Steve McNair, 1973 to 2009. NFL quarterback Steve McNair was tragically shot and killed by his mistress, Sahel Kazemi, on July 4, 2009. The football icon passed away intestate, causing his assets to be frozen in probate. This led to a protracted and bitter dispute between McNair's widow, Michelle, and his mother, Lucille. Aretha Franklin, 1942 to 2018. The Queen of Soul passed away on August 16, 2018, without having made a will. Despite repeated urgings from her attorneys, the singer disregarded their advice. Subsequently, 3 handwritten wills were found by Franklin's niece, who had been appointed by the court to serve as the personal representative of the late singer's estate. These documents, disorganized and resembling rough drafts, have thus far been dismissed as non-binding. A trial to determine which will is valid and who will manage the estate's business affairs is expected to commence in August 2021.